Hello, class. Welcome to Chapter 9, Punishment and Sentencing. Get this slideshow started. All right, so we are going to be talking about the different reasons that we punish. What are those philosophical reasons for sentencing and what they look like? So retribution is a word that we want to know. We're talking about these four philosophies. And retribution refers to this philosophy that those who commit criminal acts should be punished for breaking society's rules to the extent that's required. So retribution relies on the principle of just deserts. And I always laugh when I say that because is it desserts or deserts or what is the right pronunciation? But basically what that is a sanctioning philosophy that's based on the assertion that criminal punishment should be proportionate to the severity of the crime. The second philosophical reason, is deterrence. And deterrence refers to the strategy of preventing crime through a threat of punishment. And we have a couple of different types of deterrence that are important to understand and know, and that is general deterrence and specific deterrence. And general deterrence is this idea that by punishing one person, that society will be discouraging others from committing that similar crime. And specific deterrence is an assumption that an individual, after being punished once for a certain act, will be less likely to repeat that act again if we punish them. Now, incapacitation refers to a strategy for preventing crime by detaining wrongdoers in prison. We're incapacitating them. Basically, we're separating them from the community and reducing the criminal opportunities. And as a purely practical matter, incarcerating individuals and criminals guarantees they will not be a danger to society, at least for the length of their prison term. And then, of course, rehabilitation, which refers to the philosophy that society is best served when wrongdoers are provided the resources needed to eliminate their criminal behavior. And this line of thinking really reflects the view that crime is a social phenomenon, and it's caused by the inherent criminality of a person, but by factors in that person's surrounding as well. Now, restorative justice is a strategy attempt to repair the damage that a crime does to the victim's family, and society as a whole. And restitution refers to monetary compensation for damages done to the victim by the offender's criminal act. And the following are 5 features that differentiate restorative justice from the mainstream criminal justice system. Those are offender involvement, victim-offender interaction, community involvement, and problem-solving practices. So let's talk about the structure of the sentencing process. So we're going to first talk about indeterminate sentencing. So, and what those mean, what the differences is with those. So we know that legislative bodies are responsible for the criminal codes that are passed and for determining the length of sentences. So indeterminate sentencing is an imposition of a sentence that prescribes a range of years rather than a specified number of years to be served, right? So if we say a certain crime, you get 10 to 15, that is the range, indeterminate sentencing. And penal codes with indeterminate sentencing policies set a minimum and a maximum that a person must spend in prison. Now, determinate sentencing is basically this imposition of a sentence that's fixed by a sentencing authority, cannot be reduced by judges or other corrections officials. It's very vague, and And there can be, it's not very vague, but basically what it's doing is it's taking the vague indeterminate sentencing with those range, and it's challenging that. It's challenging the vague nature of indeterminate sentencing. And so politicians tend to support determinate sentencing because it's fixed. It's fixed. So there's a couple of terms you may have heard: good time and truth in sentencing. So good time refers to a reduction in time served by prisoners based on good behavior, their conformity to rules, or other positive behaviors. Sentence reduction programs promote discipline within a correctional institution and reduce overcrowding. So truth in sentencing laws are defined as legislative attempts that ensure that convicts will serve approximately the terms to which they were initially sentenced. And as that name suggests, the primary goal of these laws is to provide the public with more accurate information about the actual amount of time that offender will spend behind bars. So at a traditional sentencing hearing, the judge is no longer an arbitrator between the parties. He or she is now called on to exercise the ultimate authority of the state in determining the defendant's fate. So individualized justice is where a qualified judge absolutely has the discretion in making the sentencing decision. And judicial discretion rests on the assumption that a judge should be given ample leeway in determining punishments that fit both the crime and the criminal. Judicial dispositions, with whatever legislative restrictions that apply, the sentencing judge has a number of options when it comes to choosing the proper form of punishment. That's known as a disposition, and they can, imprisonment, fine, probation, restorative justice movements like apologies or letters. And community service consists of good work, so cleaning up highways, littering, and restitution is basically, paying back fines, or not fines, but restitution is more paying back a certain fee of restitution for causing harm to that victim. This idea of apologies and being able to say sorry for decisions made is definitely, as I mentioned, a role in restorative justice. So let's talk about the sentencing process and what goes on with that. So judicial discretion is often tantamounted to informed discretion. So without the aid of the other members of the courtroom group, the judge would not have sufficient information to really make proper sentencing choices. So a pre-investigation report, a pre-sentence investigation report, in our state Department of Corrections that completes these, they're called PSIs for obvious reasons. And this report is an investigative report on an offender's background, and it assists a judge in determining the proper sentences. And this report can also include a sentencing recommendation. And it goes really in depth. It interviews the victims, interviews the families of the victim, it interviews the families of the criminal. It's a long and diligent process that really helps the judges with sentencing. So we're looking at some different factors when we're talking about what's going to go into sentencing. So the jury is really the one that's making a determination of the death penalty. So we're talking about sentencing and these factors. So the jury, not the judge, is going to be the one that's deciding whether a convict is eligible for the death penalty. And there are different states have different rules on this, sentencing decision rules that go into play. So the sentencing ritual strongly lends itself to the concept of individualized justice. So in making the final decision, most judges consider two factors above all others: the seriousness of the crime and any other mitigating or aggravating circumstances. Mitigating or aggravating circumstances. So when we talk about the what these are, mitigating and aggravating circumstances, we're going to go a little bit further into this. So when we're deciding the severity, the judges and the juries are going to evaluate these two things, mitigating and aggravating circumstances. Now, mitigating circumstances are any circumstances accompanying the commission of the crime that may justify a lighter sentence. And aggravating are any circumstances that may justify a harsher sentence. So, aggravating circumstances of a crime may be something like if you commit a burglary and you do it at nighttime. In some states, that's considered, in the dark, in the middle of the night, that's considering aggravating circumstances. Mitigating circumstances may be looking at the fact that a single parent is raising kids, and that might be a mitigating circumstances they would want to look at when making a decision for sentencing. That's just an idea. But most states and federal governments really spell out what these are in statutes. So there is room for judicial discretion, but there's really no uniform or even consistent way for these circumstances to be determined. So let's talk about some reasons why sentencing reform has occurred. So sentencing disparity, and this refers to a situation in which those convicted of similar crimes do not receive similar sentences. And justice would seem to demand that those who commit similar crimes should receive similar punishments. So sentencing disparity occurs when this expectation is not met in one of the following three ways. Criminals receive similar sentences for different crimes of unequal seriousness. Criminals receive different sentences for similar crimes, and mitigating or aggravating circumstances have a disproportionate effect on sentences. So some of the things that we see with disparities might be geographic disparities. So for offenders, the amount of time spent in prison often depends as much on where the crime was committed as on the crime itself. And geographic disparities can be attributed to a number of different factors, including local attitudes toward crime and financial resources available to cover the expenses of the incarceration. And because of different sentencing guidelines within states, the punishment for the same crime in federal and state courts can be dramatically different. So sentencing discrimination occurs and refers to a situation in which the length of sentence appears to be influenced by the defendant's race, gender, economic status, or other non-relevant factor. It occurs when disparities can be attributed to extralegal barriers such as the defendant's gender, race, economic standing. And research has been done at Arizona State University and the College of New Jersey that found that the rate of imprisonment rose significantly for minorities who were young and unemployed. And this led them to conclude the disparities between races were not the result of conscious discrimination on the part of the sentencing judges. Rather, faced with limited time to make decisions and limited information, the judges would resort to stereotypes, considering not just the race, but age and unemployment as well. So few people would argue that race or ethnicity should be a factor in sentencing decisions, and that the system should be colorblind. But the Sentencing Reform Act of 1984 emphasized the ideal of gender-neutral sentencing. So women who are convicted of crimes are less likely to go to prison than men, and those who are incarcerated tend to serve shorter sentences. But according to government data, on average, a woman receives a sentence that is 29 months shorter than that of a man for a violent crime, and 9 months shorter for a property crime. So they call this the chivalry effect. And other evidence suggests that a chivalry effect, or the idea that a woman should be treated more leniently than men, plays a large role in sentencing decisions. Several self-reported studies have shown that judges may treat female defendants more gently than males, and that with women, judges are influenced by mitigating factors, such as their marital status, family background, that they might ignore with men. So how have politicians tried to fix sentencing? Well, by coming up with sentencing guidelines. So sentencing guidelines are legislatively determined guidelines that judges are required to follow when sentencing those convicted of specific crimes. And sentencing guidelines require judges to dispense legislatively determined sentences based on factors such as the seriousness of the crime and the offender's prior record. So these guidelines remove this discretionary power from the judges by turning the sentence into more of a mathematical exercise. And members of the courtroom work group use a grid to determine the proper sentencing. Now, in 1984, Congress passed the Sentencing Reform Act, SRA, and this paved the way for federal sentencing guidelines that went into effect 3 years later. But sentences have become harsher. By 2004, the average federal prison sentence was 50 months, more than twice as long as in 1984. So judicial departures refers to a stipulation in which sentencing guidelines that allows a judge to adjust his or her sentencing decision was based on the special circumstances of a particular case. With mandatory sentencing guidelines, this was where an attempt was made to close even the limited loophole of judicial discretion that was offered by departures. Politicians have passed these sentencing laws even more contrary to the idea of individualized justice. And these mandatory minimum sentencing guidelines were statutorily determined punishments that must be applied to those who are convicted of a specific crime. Further limit a judge's power to deviate from determinate sentencing laws by setting firm standards for certain crimes. So state and federal mandatory minimums. Today, nearly every state has mandatory sentencing laws. Most are related to crimes involving the sale and possession of illegal drugs. The federal government passed its Anti-Drug Abuse Act in the mid-'80s in response to the cocaine overdose of a well-known basketball player named Len Bias. And federal mandatory minimums are guided by a set of triggers, which are based on the amount of drugs involved, the offender's criminal history, and many other attendant circumstances. Now, we also know about three strikes legislation, and this is habitual offender laws. And these are statutes that require lengthy prison sentences for those who are convicted of repeated felonies. They are a form of mandatory sentencing that is found in 26 states and used by the federal government. But nearly 30 states have reformed their mandatory sentencing laws since the year 2000. And in general, reform takes one of the three approaches: expanding judicial discretion, limiting habitual offender triggers, and repealing or revising mandatory minimum sentences. So, crime victim awareness and impact is really important. So the victim impact statement, the VIS, refers to a statement that is presented to the sentencing body. It's where the victim is given the opportunity to describe how that crime has affected her or him. And they have proved really controversial, and legal experts have had a difficult time determining whether they really cause more harm or good. So we need to balance the process, and the Crime Victims Act gives victims the right to be reasonably heard during their sentence, and many state victims' rights laws contain similar provisions. The Crime Victims Act gives victims the right to be reasonably heard during sentencing, but on a purely practical level, a victim's impact statement may help judges and juries make informed sentencing decisions as well by providing them with an understanding of the whole picture. So opponents of the victim impact statements claim that they interject dangerously prejudicial evidence into sentencing, which would be governed by reason, not emotion. But research has shown that hearing victim impact evidence makes jurors more likely to impose the death penalty. We are going to take a pause in the lecture, and we'll be back.